Assalamualaikum and hello everyone. My name is Nur Amira Safia binti Kamal. My matrix number is 083432. I will be presenting the abstract of our report. This report examines the application and effectiveness of the general defense of a mistake and accident in murder cases under Malaysian criminal law. Our study focused on analysing the relevant provisions of the penal code as well as decided Malaysian court cases where these defences were raised in murder proceedings. By use statistical and numerical analysis, this report evaluates the success rate of the defense of mistake and accidents when relied upon by the accused. The findings aim to provide insight into how Malaysian court access and apply this defense, and to identify patterns in judicial decision-making. Based on the analysis, this report also offers recommendations to enhance the understanding and proper application of general defense between the Malaysian criminal justice system. Next, I will explain the objective of our study. The first objective of this study is to examine the legal principles governing the general defense of mistake and accidents under the Malaysian Penal Code. The second objective is to analyse how the defense of a mistake and accident are applied in Malaysian murder cases through statistical and numerical analysis. The third objective is to determine the success rate of the general defense of mistake and accident in murder proceedings based on decided Malaysian cases. Lastly, this study aims to propose recommendations based on observation derived from the statistical findings and case analysis. This is all of the objective.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Aris Darif bin Umali. My matric number 078246, and I will be represent a case study of statistical analysis of the defense, accident and mistake under the Malaysian murder cases. So from this topic, we have four objectives to our research. I will now explain the visual data and the statistical framework we use to the conclusion. To ensure our findings were robust, we conducted a quantitative analysis of 50 selected Malaysian murder cases spanning over 70 years from 1947 to 2025. We categorize these cases based on specific section of the Penal Code, invoke primarily section 18 of the Defence of Accident and section 76 and or 79 for the mistake of facts. So regarding the timeline, from our data, 78% of the cases occur between 2011 and 2025, ensuring our analysis reflect modern judicial perspective. However, they call a mistake anomaly. We observe a massive gap between the colonial era and present day where the mistake defensively disappear. This confirms that mistake of fact has become a legal relic. It is almost obsolete in modern legislation compared to the colonial period. If you look at our chart on court level and frequency, you will see a stark contrast. First, accident was commonly shield appearing in 98% of the cases, equivalent to 24 cases. In contrast, mistake of fact only appear in 10%, which is 5 cases. Furthermore, the 5 cases is not absolute on the murder cases. You also have the gun because of what? Because the murder has become for the mistake become a lot of relic defense in the murder cases. Furthermore, while 58% of these cases started in High Court, and the data reveal a critical distinction. While instantly defenses are often successful resolved in the High Court, over 40% of the accident and mistake cases are rejected. They are forced into the Court of Appeal, where they almost invariably fail. So the effectiveness, this brings us to the effectiveness gap. We didn't just look. Then two defenses is in isolation. We compare them against the section 84 of insanity to provide a benchmark. The data shows a clear trend why insanity defenses often succeed due to the inclusion of the expert psychiatric testimony. The defenses of accident and mistake have a staggering failure rate. Specifically, on our analysis, revealed that 80% of the mistake defenses failed because the accused could not meet the specific reasonableness test required by the Malaysian court. So finally, in our data set, we observe that the court consistently prioritized physical evidence such as the type of the weapon used, the number of wounds and the force of the impact, which is the physical evidence against the subjective claim. So, over the defendant's subjective claim of an accident, this data explain why, despite being codified in our law, these defenses rarely lead to an acquittal in modern murder trial because the court simply do not accept the subjective claim when the physical evidence suggests a deliberate act.
Hi, I'm Yasmin. Today I will be sharing the key findings from our statistical analysis. So our team analyzed 50 cases from 1947 to 2025, focusing on two legal defense, mistake under section 76 and 79 of Penal Code and accident under section 80. To begin, the main finding is that although these defenses exist in Penal Code, they are rarely effective in practice. 68% ended in murder convictions, while only 4% were reduced to culpable homicide. Moving on to the numbers, accident was the most common defense, raised in 34 cases, which is about 2/3 of the data set. By contrast, mistakes appear in only 5 cases, showing it is almost obsolete. In 80% of those cases, with the only success recorded in 1949. So to compare them, we compare with the defense of insanity under section 84. Unlike mistake and accident, insanity was far more effective, largely because courts rely on psychiatric evidence. Having seen the statistics, let us now consider the reasons behind this failure. First, the defense of mistake is failures like in the strict requirement of good faith, which means acting with due care and attention. Courts will apply an objective test. Would a reasonable person have made the same mistake? In cases involving weapons, in nearly half of the data set, the courts almost always answers no. Therefore, mistakes are rarely accepted. And now, let us turn to the accident defense, which faces its own barriers. This fails mainly because of two strict requirements. First, the act must occur during lawful activity. Yet, most cases involve in unlawful fights, which automatically disqualify the defense. Second, courts examine whether the force used was proportionate. When knives or parangs were involved, the injuries were often excessive, such as multiple wounds. This evidence of brutality led courts to reject the claim of accident. So in conclusion, mistakes and accidents are defenses of last resort with very low chances of success. Malaysian courts focus on intent and reasonableness. For this defense to succeed, the act must be lawful and that the force is proportionate. However, these conditions are rarely met in murder cases. To sum up, while these defenses exist in theory, they are practically ineffective in Malaysian murder trial. My name is Raimi and I will start the implication of findings for legal practitioners and policy makers. The mens rea in murder is a central element in criminal liability. Without the mens rea, a charge of murder can lead to manslaughter. However, when mistake or accident defense are raised, proving the mens rea becomes tricky and policymakers face a serious challenge. Murder requires intention to kill and cause grievous harm. Situations involving mistakes like believing a gun was unloaded or accident like unforeseeable death during lawful conduct can be confusing whether the accused truly had the intent. The implications of mens rea are significant. Ambiguity in its interpretation may lead to wrongful conviction or unjustified acquittal, particularly when juries struggle to distinguish between intention and recklessness. In addition, vague standards may be exploited by defendants who claim mistake or accident to avoid the liability. What's the solution for it? First, by codifying the clear definition which direct intent, oblique intent, and recklessness, narrow the definition of accident where only death was unforeseeable and not due to negligence. Next, require the mistakes to be both honest and reasonable with the evidence. Providing standardized jury direction, for example, can help the jury understanding and make more consistent decision making. Evidentiary rules also should be strengthened. For example, the accident claim should be tested against foreseeability, while mistakes claims should show the evidence that they're truly making a mistake. Ultimately, clarity in mens rea matters because it protects fairness, ensures deterrence, and builds public trust. By defining legal definitions and providing clearer guidance to the court, policymakers can strike a balance and punish the true offenders.
Alright, my name is Rodatul and I will continue with the next solution for implication on our group cases analysis of the defenses of mistake and accident in Malaysian murder cases. But for my part, I will highlight on the defense of mistake. Based on our cases analysis, the judicial reasoning is identified in this analysis show that Malaysian court apply an objective reasonableness test, which serve as a substantial barrier to exculpation since although defenses of mistake and accident are codified in the Penal Code, they are largely ineffective when applied to Section 302 charges, which mean the defense of mistake is now mostly useless in murder cases. But the findings suggest that for the defenses of mistake and accident to remain viable, since there must be a clear absence of insufficient force and a strictly lawful context, condition rarely present in murder litigation. Firstly, for lawyer scope, which lawyer must focus on shift their strategy since mistake defense is rarely successful. They should focus on stronger alternatives such as gathering objective evidence early, such as medical report or witness account proving no insufficient force and a lawful contact as subjective claim rarely succeeds. Pursue partial defenses like provocation or excessive private defense instead, and avoid over-relying on mistake as primary defenses due to their high failure rate in murder litigation. Other than that, for judges must uphold consistency such as apply a strict objective test, assessing if a reasonable person would perceive the act as lawful without criminal intent to ensure fairness and predictability in murder trial. However, under policymaker scope, they can review statutory defenses like if mistake is almost impossible to use, reform may be needed to ensure fairness in rare genuine cases.
Hi, my name is Ili Maisara and I'm going to be explaining the defense of accident. So in law, an accident isn't just something that happened. Under Section 80 of the Penal Code, an accident is a complete legal defense that can absolve you of liability for death or injury, but the margin is thin. If you fail the accident test, you could face up to 2 years in prison for negligence or 6 months for rash driving under Section 279. So according to the case of R against Ong Shun, an accident must be 3 things. First, it must be unintentional. Second, it must be unexpected. And third, it must be taken against with reasonable precaution. So to succeed in this defense, you must satisfy the 6 elements. First, the act must be unforeseen or misfortune. It must be a surprise that no ordinary person could have foreseen. Think of Basam Singh against Emperor. He was shooting at the boar, but he hit a fly in the bush instead. So, the second one, there must be no criminal intention or knowledge. You didn't mean for the harm to happen, and you couldn't have known it would. For example, the case of King Emperor against Timapa. And the third one, it must be a lawful act. You cannot claim accident while doing something inherently wrong. For example, malum in se, which is acts like murder or kidnapping. Malum prohibita, acts that are illegal because of regulations like not wearing a helmet. Example, in Kong Tok Ing, the defense failed because attempting suicide is an unlawful act in itself. The fourth one, in a lawful manner. Your conduct must be reasonable. In bespoke motoring, the driver was acquitted because he was driving normally until someone cut him off. He reacted reasonably to avoid danger. The fifth one, by lawful means. Are you using legal tools? Interestingly, in Timapa, even using an unlicensed gun didn't stop the defense because the shooting itself was in a lawful itself hunt. And sixth one, with proper care and caution. This is the good faith test under Section 52. Did you act like a reasonable person would? So the courts must differentiate between a pure accident and culpable negligence. Instead of MP against Rangswamy, a man shot at what he thought was a hyena in the rain because his visibility was poor and he was in a hunting area. It was a pure accident. However, if you are fighting, even with bare hands, like Jageshwar against King Emperor, you cannot claim accident if you hit a bystander. Why? Because the initial act of fighting was already an illegal act. So in short, to use the accident defense, you must be doing the right thing, the right way, with the right tools and with full caution. If any of these are missing, the law shifts from misfortune to negligence. Liability isn't just about what you did, it's about what a reasonable person could have seen it coming.
Next, I will discuss the policy balance between protecting victims and preventing overcriminalization. An overly broad acceptance of the defense of mistake or accident may undermine the deterrent effect of criminal law. However, an overly strict rejection of this defense risks punishing individuals who are morally blameless. To address this issue, several solutions may be adopted. First, proportional sentencing frameworks should be applied, such as reducing a charge of murder to manslaughter where mistake or accident is clearly proven. Second, judicial discretion should be exercised carefully with proper ethics oversight to ensure consistency and fairness in sentencing. Finally, restorative justice options should be encouraged in genie accident cases, particularly where there is no intention to cause harm. This balanced approach helps protect victims while avoiding injustice criminalization.